Welcome to episode 11. This is a discussion of Chapter 11 of UAE Crypto Litigation, available at www.uaecryptolitigation.com. Imagine watching millions of dollars of your money just move across a public screen.
Right, where you can see the exact timestamps and the gas fees paid.
Yeah, every single hop the funds took, you have like the ultimate mathematical receipts. But then, when you stand in front of a judge to get those funds back, they look at the data and say, sorry, you cannot prove any of this is actually yours.
Which is honestly the defining friction point in digital asset law right now. I mean, we've built this entire ecosystem on a pristine, mathematically certain ledger, but we continually forget that courts do not operate on mathematics alone.
They operate on legal attribution, right?
Exactly. When the blockchain is inherently pseudonymous, proving who controls a specific alphanumeric string at, a specific moment in time, it requires bridging a massive evidentiary gap.
So today in this deep dive, we are going to systematically unpack how the legal and regulatory frameworks in the United Arab Emirates approach this burden of proof.
Yes, we're moving from a determinative court judgment that sets the judicial baseline straight into how mature regulatory frameworks handle the exact same problem.
And finally, how private parties can architect their contracts to avoid falling into this trap.
Right, and to understand the sheer gravity of this gap, we really need to examine how courts handle these disputes in practice, specifically when the parties involved neglected to put formal off-chain documentation in place.
Right. So let's look at a 2024 judgment from the Dubai Court of First Instance. And, we will keep the specific identities anonymized and just focus on the objective legal mechanics here.
Absolutely.
So we are dealing with a claimant who initiated a lawsuit over a multi-million dirham dispute. The allegation was that they transferred a highly significant sum of Ethereum to a defendant for investment on a prominent cryptocurrency platform.
Right. And the claimant's core assertion was that after the transfer, the defendant simply closed the account, seized the digital assets, and refused to return them.
Yeah.
Which is, a classic misappropriation claim.
Yeah, and if I am the claimant making an allegation that serious involving millions in digital assets, I would assume I need an ironclad paper trail.
You would think so, yeah.
But the evidence brought to the court was essentially a file of documents containing copies of blockchain transfers, a statement of amounts, and WhatsApp conversations between the two parties.
Yeah, it's pretty wild.
You're telling me someone tried to secure a multi-million dirham commercial arrangement with the same app I use to coordinate weekend brunch?
I mean, that is the reality of many informal early-stage crypto transactions, unfortunately. The court, however, approached this with strict adherence to foundational civil and commercial legal principles.
Makes total sense.
Right. Citing precedents from the Dubai Court of Cassation, the court applied a rigorous, objective standard regarding the burden of proof. The onus rests entirely on the claimant.
So basically, the court is the referee, not the coach. If you bring the lawsuit, it is your absolute obligation to establish the validity of your claim with concrete evidence.
Exactly. The judiciary relies entirely on evaluating the evidence formally presented. And because the evidence consisted of highly technical on-chain data links alongside informal chats, the court exercised its authority to appoint a specialized technical expert.
To ascertain the reality of the digital movements, right?
Yes, exactly.
And this is where I want to really dig into the mechanics. The expert looks at the blockchain explorer, and the money definitely moved. The ledger shows the Ethereum leaving point A and eventually reaching point B.
Well, the expert confirmed a substantial quantum of assets was transferred over a period of time. But the technical report really highlighted the sheer complexity of the on-chain reality.
It wasn't just a simple transfer.
No, we are not talking about a simple peer-to-peer transfer. The expert mapped out over 1,000 individual transactions. They originated from a multitude of different source wallets and were eventually dispersed to over 100 different destination addresses.
Oh, wow. So the expert is staring at a massive, fragmented web of alphanumeric strings.
Yeah, and the is where the evidentiary chain collapsed. The expert explicitly concluded that looking purely at the on-chain data, there was absolutely no basis to prove the claimant legally owned the originating source wallets.
I mean, it's like having a receipt showing a large bag of cash was dropped on a park bench, right? And then another receipt showing someone picked up a bag of cash hours later.
That's a really great way to look at it.
You have zero proof that it was your cash you left there or that the defendant was the specific person who picked it up. The ledger shows the movement of the asset perfectly, but it is completely silent on the legal persons involved.
Exactly. The blockchain records the state transition. It records the what and the when. But without robust off-chain evidence, it cannot prove the who. and the expert found the exact same fatal flaw at the destination side of the transfer.
Right, because of those 100 destination wallets.
Yep. The claimant provided no documentation proving the defendant owned any of those 100-plus unknown destination wallets either.
So the court looks at the expert's report, which essentially says money moved, but we have no idea who controlled the endpoints. And so they dismiss the lawsuit due to a complete failure of proof.
The dismissal was really the only objective resolution available under the law. The claimant failed to discharge their legal burden. There was a late attempt by the claimant to request another expert to examine telegram messages, though.
Oh, really?
Yeah, arguing the chats would show the defendant requesting the transfers.
The court rightfully rejected that, I assume, because examining more informal chat logs doesn't magically link a legal entity to a cryptographic private key.
Right. The court reasoned that the foundational evidence was so fundamentally deficient regarding the actual ownership of the wallets that analyzing ancillary telegram chats would be procedurally improper and substantively pointless.
It couldn't cure the fatal lack of foundational proof.
Exactly. The final disposition awarded costs against the claimant.
So the court essentially says, we cannot enforce obligations based on raw transaction data alone if you didn't document anything off-chain. Which immediately makes you wonder, how is a massive, multi-billion-dollar crypto exchange supposed to operate if every single transaction carries this terrifying evidentiary risk?
That's the big question.
They obviously can't rely on WhatsApp and Telegram to run an institutional business.
Right, and that operational necessity is exactly what drives the UAE's sophisticated regulatory framework, specifically overseen by VAR, the Virtual Assets Regulatory Authority.
Okay, so how does VAR handle this?
Well, if a licensed virtual asset service provider, or VASP, was managing a client's assets under this regime, they are subject to strict, granular rules that effectively force the off-chain documentation to exist. They preempt the evidentiary black hole we just discussed.
So if you're listening to this and you've ever moved assets into a staking pool or a smart contract just by clicking approve on your browser wallet, you need to realize that legally you might have just walked onto that park bench and left your wallet behind.
That's entirely true.
How does the VAR framework protect a consumer from doing that?
It mandates a highly structured relationship from the very first interaction. Under the VA Management and Investment Services Rulebook, a VASP is legally required to establish a detailed client agreement.
What does that entail?
It's a formal, binding document that explicitly specifies the rights, the authority granted, and the exact scope of the investment mandate.
So you are formalizing the relationship off-chain before a single token ever moves on-chain.
Yes. Additionally, the VASP must conduct a mandatory suitability assessment to ensure the investment aligns with the client's financial circumstances. The days of ambiguous, undocumented terms are completely engineered out of the process.
That's huge. Let's talk about the assets themselves, because in the 2024 judgment, the Ethereum was fragmented across thousands of transactions. It sounded like an absolute forensic nightmare to untangle.
It was. The regulatory framework addresses the risk of commingling through stringent custody and segregation requirements. A licensed VASP must segregate the virtual assets of each individual client into separate wallets.
Because if a custodian dumps everyone's Bitcoin into one giant omnibus wallet and something goes wrong, trying to prove which specific fraction of a Bitcoin belongs to which specific client in a liquidation scenario is nearly impossible.
Right. Segregation makes ownership attribution legally straightforward. Structurally, a VASP providing custody is also required to be a separate legal entity from any affiliated business conducting other virtual asset activities.
Creating a firewall around the client's assets.
Exactly. And to link those segregated assets to the legal entity, ARA's Technology and Information Rulebook mandates strict access management controls.
They need an audit log of the cryptographic keys, right?
Yes. The VASP must maintain a continuous verifiable log of exactly who controls the private keys at all times. This provides the exact evidentiary link between the legal entity and the wallet address that was fatally missing in the court case.
I want to go back to the dispersal issue. In the court case, the funds were sprayed across over 100 unknown wallets. If a licensed VASP saw that happening on their platform, how does the regulation handle it?
VAI mandates that VASPs implement and maintain sophisticated distributed ledger tracing software. They are required to conduct continuous behavioral analysis to detect anomalous patterns.
So taking a massive sum of Ethereum and suddenly fragmenting it across 100 different unknown addresses, wouldn't just sit on a ledger unexamined.
Not at all.
It would trigger a massive internal alarm. I mean, the software would recognize the rapid fragmentation as a classic obfuscation technique, similar to what you might see in a peel chain or a mixing service.
Exactly. It constitutes a significant red flag requiring immediate investigation and regulatory reporting. Furthermore, for standard transfers, the VASP must provide two-stage settlement receipts.
What does that mean?
One receipt detailing the intended destination entity and a second confirming final settlement. So you have an indisputable, documented record of both the intent and the finality of the transaction.
So the regulatory framework essentially acts as a forced translation layer. It mandates that the pseudonymous on-chain activity is continuously translated into a documented, highly structured off-chain reality.
Yes, beautifully said.
But we need to address the broader market. Not every transaction involves a fully regulated VASP acting as your custodian. Say, two sophisticated private corporations want to transact directly.
Right, an over-the-counter deal, for example.
Yeah. How do they architect their private contracts to avoid the evidentiary trap from the 2024 judgment?
The text provides exceptional, forward-looking guidance on this exact challenge. The goal is to proactively build the same comprehensive evidentiary scaffolding that a VASP uses, but doing it through private transactional architecture and contractual risk mitigation.
Okay, walk me through this architecture of proof. Where is the starting line?
The foundational layer is explicit designation. You must move completely away from informal digital communications. The legal contract itself, usually within its definitions section or an attached signed schedule, must explicitly define the designated wallets or digital currency addresses.
You literally copy the alphanumeric string, paste it into the legal contract, and state, for the purposes of this agreement, this string legally represents party A. You bind the legal entity to the digital address in writing.
Right. Building on that designation, the contract must contain robust representations and warranties. A party must legally warrant that they are the lawful owner of the designated wallet, that they hold good and clear title to the assets within it, and that no third party has an encumbrance or interest in it.
Okay, so that legally allocates the risk. If it turns out they don't actually own the wallet or they pledged those assets elsewhere, they are instantly in breach of contract.
Yes.
But here is the vulnerability I see. Anyone can open a block explorer, find a wallet address with a massive balance, and paste that string into a contract claiming it's theirs. How do you prove they actually control it at the moment of signing?
That vulnerability is neutralized by implementing a wallet control attestation protocol. Before any material transaction occurs, or before the contract is fully executed, a party must provide affirmative cryptographic proof of control.
Oh, I love this. This is where asymmetric cryptography is beautiful. You use your private key to sign a randomized message provided by the counterparty.
Yeah. Exactly, like maybe today's date, the contract name, and a specific nonce.
Right, and then the counterparty uses your public key to verify that signature. It mathematically proves you hold the private key right now without you ever having to reveal the key itself.
It is brilliant.
It's the digital equivalent of, well, making someone unlock the front door of a house with their physical key before you sign the lease, proving they actually control the property.
Yes, the attestation creates a definitive, time-stamped, tamper-proof evidentiary link. It bridges the gap. It provides the exact, irrefutable proof of ownership that the Dubai Court of First Instance found absent.
What about the ongoing operational reality? A contract might last for years with hundreds of transfers.
Institutional agreements replace informal chats with formalized operational protocols. They mandate the use of formal lending requests or orders submitted through predefined secure channels.
So no more WhatsApp messages saying, hey, send the funds.
Definitely not. This is followed by binding confirmations detailing the exact asset, quantity, price, and destination wallet. Settlement finality is strictly defined too.
Like what?
For instance, explicitly stating how many block confirmations are required before a transaction is legally considered complete and irrevocable.
Okay, wait a minute. When we talk about institutional players posting massive amounts of collateral, you often hear about using third-party custodians.
Here?
Isn't the entire philosophical point of cryptocurrency to be trustless? To avoid third-party intermediaries entirely? You're telling me the ultimate legal protection for a decentralized asset is to essentially use a bank?
It really highlights the tension between the cypherpunk ethos of blockchain and the commercial realities of risk management.
Fair enough.
When a dispute arises, you cannot subpoena a smart contract. If a counterparty refuses to return collateral and they hold the private key, the asset is gone. To mitigate that in high-stakes transactions, utilizing an independent third-party custodian governed by an account control agreement is the most robust structural protection available.
How does that control agreement actually function under the law?
It legally severs the asset's operational control from its beneficial ownership. The agreement stipulates that the custodian acts as a securities intermediary. The crucial mechanism is a clause stating the intermediary will only take instructions from the secured party upon the receipt of a notice of sole control.
Oh, I see. So if Party A posts collateral with the custodian for a loan from Party B, Party A still beneficially owns the asset.
Right.
But if Party A defaults on the loan, Party B issues the notice of sole control. The original owner is instantly locked out, and the custodian is contractually bound to obey only Party B, the secured party.
Exactly. That completely eliminates any ambiguity about who is in control of the keys when a default happens. It creates absolute legal certainty.
Wow.
And the final non-negotiable layer of this entire architecture is compliance integration. Sophisticated commercial contracts make comprehensive KYC and AML documentation a condition precedent to transacting.
Meaning, if you refuse to prove who you are in the real world with standardized identity verification, the on-chain transaction simply does not happen.
Exactly. The counterparty, or the escrow agent, is contractually prohibited from dispersing a single token until identity is verified according to applicable law.
It's an airtight system.
It is. When you weave all these layers together, the precise wallet designations, the warranties, the cryptographic attestation, the formal operational protocols, the control agreements, and the compliance requirements, you construct a highly resilient legal architecture.
So you ensure that if you ever have to stand in front of a judge, your claims will never be dismissed for a fundamental failure of proof.
Exactly.
It leaves you with a profound paradox to chew on. The blockchain was originally invented to eliminate the need for paper contracts and lawyers. Yet to survive in the real commercial world, to actually enforce your rights when things go wrong, it turns out the blockchain needs paper contracts and lawyers more than anyone else.
That's the reality of it.
On-chain data is just data. You have to translate the blockchain into legally binding reality.
Right. The dispute over wallet ownership underscores a foundational challenge: linking pseudonymous addresses to real-world entities. But, legal ambiguity isn't just limited to informal transfers. Sometimes transactions that look like a simple sale of goods carry hidden complexities. The final characterization challenge examined in this part involves agreements that appear to be a simple sale, but where the operational realities imply an ongoing service obligation. Specifically, the purchase of crypto asset mining equipment, where the hardware's utility depends on a secure hosting environment. In our next deep dive into Chapter 12, we will explore Dubai Court of Appeal judgment, addressing whether a seller's duty extends beyond delivering hardware to include unwritten hosting obligations.
That brings us to the end of our discussion on Chapter 11. This chapter's structure is the standard methodology used throughout the book.
Authored by Mahmoud Abu Wasil and drawing on analysis from over 110 judgments, UAE Crypto Litigation serves as an indispensable resource for those in the digital asset industry.
To read the full analysis for this chapter and to explore the complete 7-part life cycle of a commercial dispute covered in the book, please visit www.uaecryptolitigation.com.
The discussion in this podcast is for educational and informational purposes only and does not constitute professional advice or any other professional relationship. Please consult with a qualified professional for advice tailored to your specific situation.